colleagues in China and in Asia, and good afternoon and a late evening wherever you may be. My name is Bob Fay. I'm the Managing Director of Digital Economy Research and Policy at the Centre for International Governance Innovation in Canada. And we are a nonpartisan think tank that conducts world-leading research and analysis to offer innovative policy solutions for the digital era. Unfortunately, I couldn't be in Hangzhou today in person, but I have very fond memories of this lovely city when I had the opportunity to visit in 2016 when China held the G20 presidency. At CIGI, we're very pleased to organize this session on new developments in governance of cross-border data flows, data strategies, and trade negotiations. And I'd like to thank the United Nations and our Chinese host for inviting us to present on this topic. So let me offer three brief observations before we start the panel. First, this is a topic that is of utmost importance. Cross-border data flows are embedded in today's data-based digital economy and essential to its development. But these flows present many governance challenges, especially since they touch upon many policy areas, including privacy, intellectual property, competition, innovation, trade, and national security. And at the same time, data-driven technologies continue to advance swiftly, especially in the area of artificial intelligence, posing new challenges for governance and for trade and trade agreements. Second, not surprisingly, there are differences in their regulation at the national, regional, and international levels, and in trade agreements. And it's fair to say that the regulations which exist are dominated by certain jurisdictions and spill over onto others that have little say on the regulations, yet are substantially impacted by them. And then third, these differences are likely hampering inclusive and sustainable global economic growth. But there are promising developments in how to regulate cross-border data flows and new technologies and the role that trade agreements can play. So against this background, we have a truly stellar panel of experts today to discuss this topic from many different and interesting angles. So in the order in which they will present, I'm very pleased to introduce our panelists. Henry Gao, Professor of Law at Singapore Management University and a CIGI Senior Fellow. He will discuss data regulation in trade agreements. Then we have Lorraine Porciuncula, who is Executive Director at the Datasphere Initiative. And her pre-recorded presentation will discuss cross-border data sandboxes to improve the governance of data flows. Then Alex He, my colleague and Senior Fellow at CIGI, will cover cross-border data flow regulations in China, their new developments, and their implications. He'll be followed by Patrick Leblanc, who is Associate Professor and holder of the C.N. Paul Tellier Chair on Business and Public Policy at the University of Ottawa, and also a CIGI Senior Fellow. He will cover initiatives on cross-border data flows in the US and the EU, and the implications for international digital governance. By video, we will then have Susan Aronson, Director of Digital Trade and Data Governance Hub, and Research Professor at the Elliott School of International Affairs, and also a Senior Fellow at CIGI. She'll cover the challenges AI poses for data governance and data flows. And then finally, Hangji Yu, Research Fellow in the Department of Political Science, School of Public Affairs at Zhejiang University in Hangzhou, who will present an interesting case study, at least I call it a case study, on the global governance of the transmission of digital sequence information on genetic resources. So after these presentations, we'll have time for a question and answer period. So please be sure to enter your questions into the chat on the Whoville platform. So now let me turn to Professor Gao. Henry, can you please lead us off? And as a reminder, you have roughly 8 minutes. Thank you.
For that kind introduction, my name is Henry Gao. I'm a Senior Fellow at CIGI and a Law Professor at Singapore Management University. It's my pleasure to present our panel on new developments on the governance of a cross-border data flow. So I will focus in my short presentation the regulation of data flow in trade agreements, which I summarize as the 3 digital kingdoms. So before I start the presentation, I would like to take a step back and try to put it in a bigger frame of think about the 3 main players when it comes to data regulation. First, you have the digital firms or the platform companies which controls the data. And for them, many of them, such as Google and Facebook, their key interest is to make sure that the data could flow across the world freely without any restriction. So there are 2 key demands: free flow of data across the border and prohibition on data localization requirements. Second, we have the consumers, who are the initial generator of data and also users of all these data services. For them, their main concern is that their privacy or personal data could be adequately protected. And last but not least, we have the government, which as the regulator of data, would not want the internet or the cyberspace to become a safe haven for criminals. So therefore, they might want to regulate data for law enforcement and also for national security and cybersecurity reasons. So as you can see from this overall framework, among the 3 players, they have a different interests, and sometimes I would even see conflicting interests. And this would often result in the different preferences when it comes to regulation of data. As I will outline later, as you can see, in the 3 main players in the digital data governance, we have the US, China, and EU. Each of them actually choose a different approach that champions the interests of different types of stakeholders in this discussion. So the best way to regulate the data regulation actually should be the World Trade Organization, which has a long history of regulating electronic commerce and digital trade issues. But because of the current problems in the negotiation function in the WTO, so unfortunately, the WTO has not been able to negotiate any agreement on data regulation or digital trade regulation. So instead, what we have at the moment is only a so-called JSI, Joint Statement Initiative negotiation on e-commerce, that was launched in January 2019. So instead, most of the data regulation are done by individual countries. And here I would present to you the 3 main players: the US, China, and the EU, each of which actually has a different approach, as I will explain. For the US, the main demand, as has been expressed in every trade agreement that the US has signed that include e-commerce provisions, is first of all, they want free flow of data across the border without any restrictions. And second, they would want also a prohibition on data localization requirements, which means that you should not require all these firms to localize the data. In terms of the protection for privacy, the US actually does not have a comprehensive data protection framework, unlike the EU. Instead, what you see in the US is that they have fragmented data protection regulations that can be found in sector-specific laws, such as the ones on credit reports, on video rental, and also there's enforcement by the FTC and self-regulation by the firms. So the US approach has been reflected in all of these US trade agreements that include e-commerce provisions since the first one they signed with Jordan in 2000. So if you look at all these US FTAs, especially the CPTPP and USMCA, which reflects the latest US approach, they basically include these 2 provisions and also certain other protection provisions such as the prohibition on forced transfer of a source code and also a few provisions regarding what the corporations need to do. The US also has been negotiating the TISA, but the TISA, the Trading in Services Agreement, has been stopped after Trump came into office 6 years ago. So currently, the only negotiation the US is participating is the JSI e-commerce negotiation at the multilateral level. And for the EU, it has taken a different approach compared to the US. The key for the EU is protection for privacy, as evidenced by the EU's General Data Protection Regulation, or the GDPR. And the EU actually, if you look at the GDPR requires that for other countries, if they want the data to be transferred to their country, they would need to make sure that they either adopt the same regulation as the GDPR, or that regulation is regarded as being equivalent to the GDPR. So for a long time, the EU was not able to form a uniform position because of the internal debate between two divisions in the EU, the DG on trade and also the DG on justice, which are in charge of trade agreements and privacy protection. But in 2018, they was able to finally reach an agreement so that they would agree to horizontal clause on free flow of data and also ban on data localization requirements. But at the same time, they affirm the EU's right to regulate, especially on privacy protection, and this would not be subject to the investor-state dispute settlement mechanism. So even though currently, if you look at all these EU FTAs, they have not included really strict provisions on privacy protection, but the rules in the GDPR could potentially be quite intrusive. Now, for China, the key is cybersecurity or cyber sovereignty. President Xi has explained on several occasions that there is no national security without cyber security. So as you can see, China has elevated the cybersecurity to the level of national security. And because of that, China has strict controls on cross-border data flows. And on privacy, there is no law on privacy protection until 2009. But even after the first law on privacy protection was introduced in 2009, there are still quite weak provisions in the legal system of China. And also, when China introduced the cybersecurity law, 2017, there are also requirements for data localization, which, as you can see, are actually quite different from the US approach. Traditionally, in China's free trade agreements, they have not been keen on including e-commerce provisions. They only started to include e-commerce provisions in the FTA with Korea and Australia, but these provisions focus mainly on e-commerce trade facilitation provisions rather than data flow provisions. So why do we have all these differences among the three players? I think there are two main reasons. The first reason is because they have different commercial interests. If you look at the top 10 digital firms in the world, 6 American firms, 4 are Chinese firms. But the American firms and Chinese firms are very different. So the American firms on the list would include firms like Facebook, like Google, which actually specialize in digital trade or data trade. So in other words, they do not sell physical products. Instead, the products they provide are purely digital products. So that is why they want to have a free flow data across the border. But the Chinese firms on the list, if you look at the top Chinese firms on the list, these include Alibaba and JD.com, which are still traditional trading goods firms. The only difference is that they are not providing these services through their platform online. Of course, you also have some Chinese digital firms on the list, such as Tencent, but the main product of Tencent, for example, WeChat, is only used by Chinese and also overseas Chinese, so it's not really a global data product, unlike Facebook or Google. So that is why the US focus on digitized products or data flow, but China focus on physical goods or trade facilitation. In contrast, there is no EU firms on the top 10 list. So that is why the EU has been introducing all these strict regulations. I mean, a cynical review could be that the EU is engaging data protectionism to enforce all these strict laws so as to prevent American and Chinese firms from encroaching in the EU market. The second difference is that they have a different regulatory philosophy. For a long time, the US has believed in the self-regulation by this sector. And actually, they believe that the reason why the Silicon Valley was able to develop so fast was because there was no regulation by the government. So if you look at the US domestic law, for example, the Telecommunication Act of the US, they have emphasized that they should make sure that the internet sector would remain unfettered by federal or state legislation. In other words, they regard government regulation more as a barrier to the development of the sector rather than to facilitate the development of the sector. But for China, they have a long history of a heavy government intervention since the beginning of the internet. When internet was first started in 1994 in China, Chinese government first started to regulate the hardware. So if you want to connect to the internet, you have to go through officially government-sanctioned gateways. And then they started to regulate the software, and also they started to regulate the content. And the latest trend, as you can see from the cybersecurity law and data security law, is the regulation of data. But the EU, in contrast to the US and China, the difference is that they have a strong tradition of protection of human rights. And this is a new trend that started after the Second World War, because they have seen such a huge atrocity because of the Second World War, so they want to really to protect human rights. So that is why you saw the European Convention on Human Rights, the European Court of Human Rights, and also in the GDPR, one main difference between the GDPR and previous privacy regulations is that in the GDPR, they have emphasized repeatedly that privacy is a fundamental human right. That is very different from the US approach. The US approach actually regulates privacy more as a consumer right. In other words, if you are a consumer in the video rental business, or if you are a consumer that want to apply to a credit card, then you have such a right. But if you have never rented a video or you have never applied for a credit card, you do not have such a privacy right. But the EU approach is fundamental human right, which means that so long as you are human, you have such right. You do not have to be a consumer in a specific sector. And in addition to the three jurisdictions I mentioned, I should emphasize that such three different approaches not limited to these three jurisdictions. Instead, it is a global phenomenon. So if you look at this study that was done by the OECD, for example, you can see that among the countries in the world, each of them actually fall under one of the three models that I mentioned just now. Last, I want to look at the future and see what the future would be like. On the one hand, you have three distinctive approaches, but on the other hand, you start to see the convergence among the three approaches. For example, the US has started to adopt some of Chinese approaches by enacting restrictions, for example, on TikTok and on WeChat, both are Chinese firms, for national security reasons. On the other hand, the EU started to accept the US demand for free flow data and also prohibition on data localization requirements. And also China, for a long time, many people believe that China could never accept free flow data and prohibition of data localization requirements. And I always disagreed with this view, because if you look at the way the Chinese regulation has been developing, what they have been doing is basically they have been trying to fine-tune the restrictions on data flow and make sure that you would only restrict the ones which are absolutely necessary. So that is why, for example, you see when the RCEP was signed 2 years ago, actually China agreed to the provision on free flow data and on prohibition on data localization requirements. Of course, this is conditional on the right of China to invoke the public security exception and also the public policy exception. But the good side for this is that China starts to accept the free flow provisions. So what I presented today is very short, but this is based on three articles I've written over the years. The first one, which provide a comprehensive overview of the US approach on data regulation. And the second one compares the approach between the US and EU. And the third one compares, in addition to the US and China, the approach between US, China, and the EU on these data regulations. So that concludes my presentation. I will be happy to take questions later. Thank you very much.
Okay, listen, thank you very much, Henry. And We are now going to go to a video. So if you'll just give me a few seconds here, I'm going to queue up the video.
Hello, my name is Lorraine Persuncula, and I'm the Executive Director of the Datasphere Initiative. Hello, my name is Lorraine Persuncula, and I'm the Executive Director of the Datasphere Initiative. It's my pleasure to speak with you today at the United Nations World Data Forum. I wish that I was there with you in person, but hopefully you have wonderful discussions after all the speakers have presented their points. So today I'll speak to you about cross-border data sandboxes. And before I start, I wanted to contextualize, because we are in a UN event, and talk a little bit about the context of data and digital within the broader international processes that the UN is leading. And I wanted to make a reference specifically for a report that just came out a few days ago on the High-Level Advisory Board on Effective Multilateralism. And I wanted to highlight a few of the recommendations that it made and conclusions in this report, because I think it's a nice context setting for the problem of data and digital in this space. And the first one is that the report concludes that the UN system and the multilateral system in general needs to support a just digital transition that unlocks the value of data and that protects against digital harms. And so that's very important in terms of creating value, but at the same time, protecting against harms. And the second one is the evaluation, correct in my view, that the multilateral system is lagging behind emerging fast-moving trends, and that at this stage, it's unable to anticipate and to respond to the risks before they escalate beyond control. And they have a number of recommendations in the report to build a more nimble and responsive system, and they're basically setting up an international council on a few items, setting up an international agreement or an international process. And I would like to argue today that we're not being bold enough, that those are traditional tools well established by the international system, but I would like to make the point here that they're not sufficient. And certainly they're not sufficient to address the issues that we have today regarding data and artificial intelligence. And so for me, the response, and one of the possible responses, comes from building more agile frameworks for responding to these issues. And that's very much in the mission statement from the Datasphere Initiative. And my contribution here today is to speak about one possible tool, which is sandboxes, cross-border sandboxes for data. So what are sandboxes for data? They are nimble spaces where we can actually come up with a sharing opportunity, either in terms of data or in terms of sharing experiences between regulators and different innovators. And we talked about this in a report that we launched a year ago, with the support of the UK government in the context of their G7 presidency that was coming out. And we mapped what were the lessons learned from other sectors that had used sandboxes to improve their regulatory systems, but also in terms of how this could be used for data, and also how this could be used across the international system to improve international cooperation. So in the report, we differ in terms of the taxonomy, and we try to really encapsulate that in two definitions. For the first one, regulatory sandboxes, which are really those spaces and collaborative spaces where we can bring together regulators, service providers, etc., to provide dialogue and guidance on how data is handled. And the second one, operational sandboxes, where it's actually testing environments where data can be handled and innovations and products tested upon. We also look into the literature to see what are the differences in terms of use cases and the benefits that sandboxes can bring in general, and the advantages that this tool can really bring to companies, for society, and for regulators. And for companies, it's ultimately about giving access to get regulators in their own expertise. For society, is very much about trying to understand those massive innovations and understanding what are the different implications for the greater public and for the policy systems around evolving technologies, practices, and norms. And for regulators, it's very much about making sure that they have a first-hand contact with the latest technological developments. So all in all, Sandboxes can bring a very effective way to provide a multi-stakeholder forum where you can help build more trust between the different parties, but also spur innovation in how collaboration is made. And then for us, what we wanted to look as well is what are the kind of groundbreaking different technologies that can actually help in terms of addressing some of those issues in a different way that are not necessarily already anticipated within current regulatory systems, for example, or within current spaces for data sharing. And those are basically three. They are the notion of what are the roles of emerging intermediaries, such as data fiduciaries, data cooperatives, data trusts. The role also of privacy-enhancing technologies, such as homomorphic encryption, and also specific browser solutions that could be used for data sharing. And we look in the report into the importance and the contributions of each one of these. We also look into what sectors can actually have sandboxes designed upon. And we look into an application for collaborative solutions in innovation, trade, and competition. We look into what are the potential for sandboxes to address issues specific for health and its impact on inclusion. We also look into issues related to mobility and effects around data regarding the environment, such as CO2 emissions, and also around biodiversity and value of data for research, science, and development. We also look into the report into a number of challenges that can exist around actually designing and implementing some of those tools and sandboxes across border in specific, because there are particular risks and challenges, particularly in trying to use them at scale, because sandboxes can have a high cost and there are obstacles for obtaining funds, particularly from the perspective of regulators, but also in terms of just aligning different incentives and priorities between regulators and different stakeholders that are in the sandbox exercise is a rather difficult challenge for us to actually overcome. And then we also propose a roadmap in terms of mapping those challenges and making sure that we are anticipating some of the difficulties. And those are choosing the right partners and issues and scoping out how we can actually align priorities from the get-go, setting up a strategy and goals that are defined enough so that partners can work together, identifying and engaging other stakeholders and defining the role that they will have within the sandbox experiment, but also agreeing on the format, on the duration, on the funding. And some of the key questions are, what kind of sandbox is it envisioned? Is one that is more operational? Is it a regulatory one? Is it a hybrid between the two? How the resources will be allocated? But also, what are the key issues and information asymmetries that need to be addressed and anticipated, and preparing for evaluation so that we can actually have lessons learned from this process. In conclusion, cross-border regulatory sandboxes or cross-border operational sandboxes can be used to establish and bolster more compliant but also agile data governance, and also can help solve problems in a way that is less linear than other traditional methods would struggle with. They are still in the infancy, particularly cross-border sandboxes. So there is very few examples in the world of successful cross-border sandboxes for data, but there is need for more time and resources to pilot some of those solutions and to actually establish a mechanism where we can share experiences on what works and what doesn't work. We also mapped a number of pending questions in terms of how we can look into the challenges that still exist in terms of responsibilities of actors, how cross-border sandboxes could manage both personal and non-personal data, for example, how we do about storing data locally and making it more flexible within regulatory sandboxes. And so there's a number of questions that we still need to address, but we are very hopeful that this is one possible avenue that many different national authorities are looking into within their domestic context, and that this could be transposed for looking into advancing international cooperation in the data space. On our side, as an organization, we are going to announce very soon a global forum on sandboxes for data, and that covers many aspects of the issue in terms of bringing together a group of experts to share good practices and experiences, building capacity building so that we can actually share the basics of what we know about sandboxes and how to set it up, and what are the use cases and the regions in the world that have effectively implemented sandboxes, but also on bringing together a group so that we can pilot new experiments in a way that are more international and that cross borders. I would invite everyone to connect if they are interested in joining our effort. Thank you so much.
We thank Lorraine for that. Alex, you're up next, please.
Thank you. And I will share my screen. Okay. My talk today, I will focus on China. With my talk, I will go through the China's cross-border data flows regulations and talk about the new developments and the implications to the world. So first, China's laws and the regulations on cross-border data flows. We have 3 data-related law. As we know, cybersecurity law, data security law, and personal information protection law. And we also have 2 measures and the regulations which provide the details for the implementation for these data laws I just mentioned. As we know, in China, laws are in general very broad, the lack of details for implementation. So that's why they introduced the 2 measures and the regulations. So under this framework, I summarized 5 situations that requires a security review on data export from this state laws and the regulations. So you can see from these situations, you can see important data is the keywords, because any export data that includes the import data, you should apply for the security review on data exports. And the last situation is stipulates that other situations defined by the CAC. This is we call the provision, the catch-all provision, or in Chinese, 兜底条款, which means try to cover all the possibilities that is not defined in this law. So which will give the regulators in China great discretions on the cross-border data regulations. The main problem in the laws and the regulations in data export in China, I think it is the vague and broader definition of key items, key terms. In particular, what is the scopes of the important data and also the core data too. Article 73 of the regulation on network data security management already gives the scopes of the important data, but it is too comprehensive and too broad to be used for the regulation for the data export. We also lack of the specific scope for what is critical information infrastructure, which is not available yet. Other problems include the different definitions of the key terms like data processors, which is defined differently in different laws. Other problems also include the lack of feasible regulations and measures for data export. So to solve that problem, China further introduced the measures to clarify and facilitate security review process for data export. So we have the guidelines for application for security assessment for data exports. And we introduced the data standard contract for exports of personal information. And also produced renewed the guidelines to identify what is the important data. In this guidelines, the last one, it listed 6 principles and 14 factors or categories to identify what are the scopes of the important data. But again, the problem is still, these scopes are still too comprehensive and too broad. I think they need to be further streamlined and clarified so the data export could be feasible. And now let me talk about what China, why and how China could relax the restrict on the cross-border data flows. First, we have articles already exist in these laws and regulations in China, which provide the legal foundations for China to take a flexible position on free flow of the data cross-border in the future. You can see here is the Article 1166 of the Data Security Law. Basically, these articles encourage China to follow the regulations of international agreements or treaties China already signed or joined to promote the safe and the free flow of data cross-border. And why China should do that? Obviously, it's for the economic growth and the trade development. Data as a core engine for economic growth has already been recognized in the policymakers in top leaderships. So that's why China wants to unleash the value of data to promote the economic growth at the age of digital economy. So that's why China submitted the applications to join the CPTPP and the DAPA 2 years ago. And also, geopolitically, China wanted to engage in the international rulemaking in the digital economy and also want to facilitate its large digital firms like the Alibaba, Tencent, Baidu to compete in international stage with the counterparts like Google and Facebook. How China could or would do that? First, you needed to more specific values or more mechanisms to facilitate cross-border data transfer. China already, like I just mentioned, China has already doing something, but more needed to be done. I think the most important thing is that you have to improve the data classification management system. Only a system like that exists, so a data export could be possible. The ideal situation is to create a so-called negative list. So beyond that list, any data can be exported freely without the data security review, without the essential restrictions on that. But the thing is, the key thing is here, what kind of data should be put on that list? If too much or too many data added to that list, that will make this list meaningless. And also, you need to streamline the national security review system for cross-border data flows. Some research recommended using the idea from Europe. They created some whitelist between China and some countries. So data flows between China and these countries could be, done freely without any restrictions. Just to be clear, all this negative list and whitelist is just the idea in a theoretical discussion stage, not in practice yet in China. If we see there is going to be a roadmap for China's possible relaxation for regulations of data exports, I would say it could be the free trade zone or free trade port, like maybe China will do it in Hainan Island, the province island in the coming years. And China also can adapt some, the idea is based on the China's past experience, we try on the experimental ways, try some pilot programs in a certain area. If they went well, then we can spread it to the whole nation. And China, some scholars also talk about some ideas like the digital customer territory. And again, this is just some theoretical discussion. And finally, let me summarize the talk today. I have some talking point here, but there is two things I want to emphasize. In terms of data governance in China, including the cross-border data flows regulation in China, I think regulators China are seeking a dual goal of boosting both security and economic growth, which means similarly, these two goals are contradictory to each other. But the thing is, China wants both. And China, Chinese policymakers tend to like the dialectical thinking, which means you need to balance the two top goals between security and development. So the key things here is that when to prioritize the security and when to emphasize the other goal, economic growth. And the final point, a glimmers of a convergence of regulations across border data flows in the Europe, United States, and China, like Henry mentioned a little bit earlier. I mentioned this just because a lot of practice and idea that China is trying to do in China is borrowed from the practice or ideas in the Europe, especially the GDPR, like the idea of a whitelist, the standard contract. All these ideas is borrowed from Europe. So in that sense, we think could be a glimmer of a convergence of the regulations on cross-border data flow among these three data realms. I'll stop here. Thank you.
Okay, thank you very much, Alex. We'll turn to you, Patrick. We are actually running out of time. So if you could please pick 8 minutes, that would be great. Thank you.
Thank you, Bob. I'll try to be as quick as possible. So the premise is a bit like Henry's presentation about WTO negotiations not really going anywhere. Although I will argue that even if we do get an agreement at WTO, I don't think that it would really lead to cross-border data flows with trust. So on that, I might be a little bit more pessimistic than he is in terms of what the WTO can achieve. In fact, I and Bob have argued for along kind of similar lines for something more akin to common standards and what I would call a single data area, where countries would share common standards, common rules, and within those would be able to flow data, both personal and business, but under a similar set of regulations. Now, the reality is that even if that seems to be the ideal situation from an economic perspective for businesses, that is not the case. And one might have expected that, Henry again talked about convergence between the three kingdoms. One might have expected maybe a bit more convergence between the European Union and the United States. But in fact, it seems the opposite is happening. Interestingly enough, if we look, we know on the European Union side, there's the GDPR adequacy for flowing personal data. But now the EU has embarked on a new initiatives, which are these bilateral digital partnerships. It's already signed 3 with Japan, Korea, and Singapore. It is supposed to begin negotiations with Canada over the summer. So this is a new thing. I mean, it's obviously these partnerships are much more supposed to be much more collaborative, but underneath it says that the EU makes it very clear it's to be done with like-minded countries, and part of the work is to create common rules that could be in a way exported, except that that's going to be done bilaterally, and that seems to be the new approach that the European Union is doing. For its part, we know the U.S. obviously was behind the e-commerce and digital trade chapters in CPTPP and the USMCA. It's also signed a digital trade agreement with Japan, which is basically the CPTPP USMCA digital trade chapter that it agreed with Japan. But in the meantime, now it's gone and pushed the Global Cross-Border Privacy Rules Forum, which is basically the APEC rules that the US is trying to take away from APEC. And presumably one can think that it's to be able to develop these privacy rules away from China and China's influence, obviously, within APEC. In addition to that, the EU has moved forward. The United States have moved forward with the Indo-Pacific Economic Framework and the Americas Partnership for Economic Prosperity, of which digital trade is part. So again, what are we going to see? Are we going to see something similar to the CPTPP or the USMCA, or something kind of different? But again, it kind of adds other initiatives which superimpose each other. And to quote Jagdish Bhagwati, was talking about the spaghetti bowl. Now it seems that we're having this proliferation of digital agreements or digital trade chapters, etc. And so kind of more and more noodles are being added to this noodle bowl of digital trade governance. And on top, and the EU, obviously, and the US have not managed to resolve, although they're negotiating, the failure of the privacy shield that they had negotiated. So, interestingly enough, although we would expect that there would be more convergence, more attempts to work together, and then rally countries around the US and the EU, whether it's Japan, whether it's the Republic of Korea, Singapore, it seems that in fact the EU and the US are kind of competing against each other in order to set the rules of the game when it comes to cross-border data flows, but certainly trying to make sure that it does not involve China. But instead of cooperation, it seems that we're seeing more competition in a way. And then you have other countries like Canada, Japan, who are kind of playing on both sides and trying to satisfy each side's demands in a way. And ultimately, the fear is that this will make it much more complicated for businesses across the world to try to comply with all these different rules and then all these different agreements. So to me, instead of converging, what I'm seeing is just a proliferation of agreements, or at least attempts to negotiate new agreements that ultimately will just make it more complicated for businesses and will not achieve this goal of flowing data across borders in a trustworthy environment. So I'll stop here. Thank you.
Thank you very much, Patrick. Could we now please run the video of Susan Aronson?
Greetings from Washington, D.C., or actually the suburbs, where today I'm going to talk about the fact that new models of AI are going to upend our current approach to data governance, and we should all be thinking about what we're going to do about it, whether you live in China or Greece or Canada. You need to be thinking about these things. Okay, so right now, the current system of cross-border data flows is a patchwork that is governed by intellectual property rules, and many of the data online is public and it's easy to retrieve, and some of that has accrued to governments, and some of it is actually web scraped on forums or social networks like Twitter or Reddit. And that could be a violation of privacy, and so we're all going to need to think about it. But let's begin by talking about, what do I mean by AI? I'm going to use an internationally accepted definition, that of the OECD, which is a machine-based system that has the ability to make predictions, recommendations, or decisions. And it is everywhere, whether you use it for spell check or you use it for Netflix. So the difference between most types of AI and generative AI is built on huge data sets and a neural network like we have in our own brains. And the idea is to try to generate something new, whether that is a short story, whether that is an essay, or it's a prediction or a recommendation. And it should concern people regarding data governance, because most of the large language models that we have become familiar with are global. And so they take personal, public, and proprietary data from around the world. But they shouldn't be taking proprietary data, right? And I think that this is leading to protectionism, and I just cite as example what's happened in Europe. So Italy has banned ChatGPT. Canada's considering investigating ChatGPT, and so a ban is quite a response, right? So what's happening here? First of all, data is really easy. It's cheap. It's easy to store and move across borders. It's also easy to reuse at the same time that many firms and governments hoard it. Data is essential to national security and economic growth, but nobody knows how to govern it. And that is the problem. So these days, two countries, China and the United States, have 94% of all AI funding, 70% of researchers, 90% of the market of the world's largest digital platforms. And the fact that two countries dominate this leads to a perception that markets are unfair, but it also leads to a perception that two countries that are dominating AI are going to dominate all different types of data. So what do trade agreements say about this? As I said, trade agreements are the main internationally accepted venue where we govern data. And they say we should cooperate on AI. There's nothing binding related to AI. They say that algorithms, only through exceptions can nations demand that another nation disclose an algorithm. So you can't insist that a firm or a nation disclose an algorithm, but yet at the same time, many governments have focused on trying to make AI more explainable and transparent by asking for algorithms to be made public and transparent. So there's a contradiction between what people say they want to do and what they're doing. In terms of public data, it's really interesting. The most recent trade agreement would be between the UK and Singapore, and they are the first governments to say not only that public data should be provided in machine-readable format, but it should be made available in an easy-to-read API, application programming interface, and regularly updated so that it's easy to scrape the web for public data. And I think we need to think about that. Do you really want data from, let's say, Canada's census to be freely shared around the world and no funds paid to the Canadian government for the use of that data? That's something to think about. Moreover, trade agreements really don't say how you can share data, how you can mix data, who is liable when data is incorrect, who is liable when AI is incorrect. So there's all sorts of issues that we all need to think about, and yet we have yet to do it. There's also issues about what is a trade barrier related to AI. And so an example of that could be any form of algorithmic regulation. So the right to a explanation, which is what is in GDPR when an algorithm is used. Competition policies could be seen as a barrier. When nations ban apps, that's a trade barrier. Cybersecurity rules. I don't yet see governments thinking about it. Yet the government of China has been thinking about it. They're at least at the national level, and they have put in place regulations that require that firms minimize the use of algorithms and data scraping. There must be a reason why firms take data, and they have to provide that. So China is definitely ahead of the curve compared to other nations, although the Chinese government is exempt from these provisions. That is of concern. Okay, some other things to think about for people who care about data is that ChatGPT, as an example, recently passed several exams, including the bar exam. So is it a service under trade agreements? No one knows. We also don't know how to deal with issues like copyrighted data, because just today the Washington Post reported that many of these generative AIs utilize copyright, and they essentially have stolen it, have not acknowledged it, and the United States is starting to see many court cases along those lines. So I say to you that if you care about data governance, data sharing, and you understand that trade agreements are the place where these things are regulated, we need to rethink these rules. And I hope you'll join me in coming up with new ideas to do so. Thanks for hearing me out.
Okay, well, that was a very interesting presentation from Susan, and we thank her for that. Our last speaker has not arrived, and it could be the time difference is not favorable. So we're just going to turn right now to a very quick Q&A period. We have 5 minutes left. And we did have one question that had been posed to us on Whova, so I'm going to ask that question. The question is there a consensus over a framework about data protection where to depart from? And I think really what they're saying is there a framework out there that countries can use? I think I know what the answer is to that, but why don't we turn to our panelists? Henry, if you would like to take a stab at that, or Alex or Patrick. It might be easiest. Maybe Patrick, we'll start with you.
Thank you, Bob. Well, as I mentioned in my presentation, I don't think there is. I mean, there can be some commonalities, obviously, but I think right now what we're seeing is certainly the EU, obviously with the GDPR, has moved in one direction. The US doesn't really know in which direction it's moving, although it's pushing this global cross-border privacy rules forum, interestingly enough, without having a national data protection or privacy protection regime. The states, the US states, are putting this together in a way and are tend to follow much more what the EU is doing. If we look at California, which has taken the lead certainly at the states level. So in a way, you're seeing kind of bifurcation in a way, and why that is not clear. I mean, I think Henry mentioned some elements in terms of differences in philosophies and in the political economy, but clearly right now I would say there is really no basis. But we'll see. Maybe if the EU and the US can agree on some kind of new privacy shield, maybe that will create the basis for something at the international level.
Yeah, I mean, the US and the EU have their trade and technology forum, and who knows what will come out of that, although I don't know where that leaves the rest of us. Henry, are you able to answer that question?
I will try to answer that question. I guess even though, I share many of the opinions with Patrick, I guess it's more of a perspective of whether the glass is half full or half empty. So Patrick is of the view that the glass currently is half empty, and I'm the view that the glass is half full and might become more full in the future, because if you look at some of the discussions that they are doing, like you mentioned, Bob, the Trade and Technology Forum between the US and EU, and also the cross-border privacy rules here in the APEC framework, and also the WTO e-commerce GSI negotiations. There could be a possibility that the parties could reach some sort of a compromise agreement, especially in the WTO, because what I understand from my colleagues in Geneva is that they are aiming to have a kind of a preliminary agreement by the time of the next ministerial conference, which will be held less than a year away from now. So hopefully by this time next year, we could have some good news from Geneva. Thank you.
Well, you know what? I think that's a good place to stop on a note of optimism. So, why don't I extend a big thanks to our panelists for sharing their insights? And I'd like to thank once again the UN and our hosts in China, as well as all the participants who have listened into this webinar. And I wish a continued successful conference. And we're very pleased to have participated. So, a very good night from Canada. Thank you.